Afternoon, everyone. Welcome. It's 1 o'clock here on the East Coast if you're seeing this live. Kenneth Lang, I have Hanan Isaacs. I believe I pronounced it right, Esquire. He's a lawyer. He does a lot with employment law, and I've wanted to have on for a very, very, very long time. We've seen each other at networking events. We've tried to make this happen. And first, I have to thank you very much, Hanan, for coming on today.
It's my deep pleasure, Ken, and thank you very much for arranging this event today. I'm really looking forward to it.
I know that one of the things my groups always have questions about are legal, what's allowed to be asked, not allowed to be asked, disability, and things like that. And I think what we'll start to do is I'll ask some general questions, and I hope that my audience, when they join in, feel free to ask as well, because one of the challenges that we have or people have when they're looking for an interview is what can they ask? Also, what can an employer ask? And there's some I know it's specific in some cases to states, but I'm sure from a general perspective, what are some of the questions that hiring managers or / recruiters really are not allowed to ask in your experience?
So the obvious ones, and this would be violating federal law as well as state of New Jersey law and most other jurisdictions, I'll say probably all, are the big ones, such as getting into issues of race, color, national origin, even if it's done in a light-hearted way or a kidding way, age, certainly, disability. A crude interviewer would say something like, I notice you came in here walking with crutches. Can you tell me whether you think you could actually do the job that we have for you here? Right? Now, that employer can get to the same question in a different way. And what they should be asking is there anything about your life that would prevent you from getting to work on time, staying all day, and leaving at the end of the day? Question mark. And then leave it to the interviewee to say, well, I have a temporary disability. You see, I'm walking with these crutches, and as long as this and that happens, I'm okay. Religion, asking people about religion. I know I've heard of one employer, for example, who will say to prospective employees, listen, I'm a very religious person, and I want everybody here to have a set of morals and standards that fits in with what we want. You can't do that. That's just not permitted. So anything having to do with things that cannot change, or even if it's volitional in the sense of religion, it's a faith-based thing that the person's not going to change. You have to leave them alone about it.
So I'd love to know at this point who's joining us here. Love to get an idea which of our people joined us, and a lot of people were interested in also asking some questions. So I think what I find also is when I've been asked some questions over time, how do I respond back to the interviewer that it's not an appropriate question, or do I just kind of brush it off because I want the job, but at the same time, they're asking something that might be out of line?
This is a difficult issue. If you go with your gut reaction and you challenge somebody saying, that's not a proper question, or if you say, I refuse to answer that, you may well get an answer that's predictable, which is at the end of the time or in some later communication. It was great meeting you. We didn't pick you, go on to your next thing. So, but I think it's a double-edged sword, because if you fail to notice that thing, if it's really glaring, the question is, what kind of a workspace are you going to be in if they pick you? I work for myself, so I don't have the same issue that perhaps somebody else does in that regard. But that noise in the background, unfortunately, we're having some housework done, and I don't know
Right.
about that.
That's all right.
I think it stopped. So you have to be careful with it. You could try kind of a sideways approach and say, well, I'd rather discuss my resume, or I'd rather discuss my background, or how I can handle this or that. You could try your best to ignore it. Some people will say, I really need this job. And if that person says they're ultra religious and what about me, I'm going to say me too. I'm not saying you're wrong for doing it, but if it bothers you and it would continue to bother you if you work there, you're going to have to decide either deal with it or be somewhat quiet about it, but pledge that you're not taking this job, or say, this is an improper question. You can say it nicely. I don't
Mhm.
believe that's a correct way to ask me about my availability as to how many kids do I have and how many more am I thinking of having. You know, there's another one that's a little more subtle that I'll bring up, which is New Jersey and some other jurisdictions have a rule that you're not permitted as an employer or a recruiter or an interviewer to ask about somebody's prior criminal record. You cannot do that on the first round, the second round. In the last round, the New Jersey rule is you're allowed to look it up for yourself as the
Mhm.
employer. Now, what's the basis of that? What's the rationale? The thought is let the employer fall in love with you. And then when they find out that you served time X years ago, maybe they won't care. But then again, maybe they will. And if they did what they're supposed to do and wait till the last round to find it out, you can be denied the job on that basis. That is lawful. But it's an interesting kind of a back and forth in that way.
So Joey had a question, which is the converse. Are there questions we as job seekers can ask? I mean, are there things we should not be asking of them?
Um, my best response to that is I would say it wouldn't be an illegal thing. It's not the same for the employee. And there are things that the employer cannot ask that the employee can share. Here's an example, relatively new. Um, New Jersey has a statute that says no employer shall ask the salary history of any candidate. That's an amazing change. And the reason for the law is sort of the general category will be pay equity. It's a big category, and there's a number of components to it. But one of them is don't ask the person's salary history. Why is that? Because some employers, many employers, will say it's like a bargain. If I can get the same job done by a very well qualified candidate who's willing to take much less than the others on the list, well, then I'm just going to drive to the bottom as much as I can. But the other side of that is, hey, you have a job as an employer that you know has a certain worth to you in your place, and that other employers similarly situated may be willing to pay $125,000. But if you get somebody who says, I'll take 65, well, you just got yourself a massive bargain. So, but where it shifts is it's okay for the employee to say, this is what I'm making. It's not an improper statement, and the employer could take it into consideration. So there are some of these statutes and policies that are what I would call a back and a forth. But as far as any kind of bright line, you're not allowed to ask a question of this or that. Well, I'm going to say, for example, New Jersey does not have something that New York just implemented. Again, it's a pay equity type thing. We have too many people who are not being compensated in a way that's similar to too many other people at the same level, whatever that level may be, right? So you have, say, a white male who's getting $100,000 and a black female for the same work who's getting $65,000. So there's a couple things about that. Some employers will tell you you're not allowed to talk about that. We don't want you sharing salary information. New Jersey has gone the other way on that. You're actually permitted to do that,
So
right?
can you
So that's
ask?
a way to get around it. But New York just passed a law that said, this is New York City, that
Mhm.
said when an employer puts out an advertisement or sends out recruiters with information about a job opening, the employer has to tag the job with a salary range. So now you know you're pitching at 90 to 110 or 55 to 70, and you can go in and say, well, if you want, I've been making 65,000. So I think I'm in your range. They They couldn't, in New Jersey, you couldn't ask that, but you are allowed to say it, right? Or you just say, okay, that's your range. I think I can fit into that range. And then based on your qualifications, and the variations could be how long you've been in the field, your educational background, your special skills, things like that. Those can appropriately differentiate between two people who say have been on the job around the same amount of time, but one of them is quote unquote much better qualified. So the employer can use those criteria,
let's
but
ask
not
the
these
question.
arbitrary ones.
You can absolutely ask for salary requirements. In fact, it really, if they're not shared with you, you really have a right to know that. Now, Kelly brings up a thing which I was going to talk about in a little while. Any red flags candidates should look for regarding an NDA or a non-compete agreement before signing an offer? Because I know we talked about this before. I remember when I was at LinkedIn itself, I had to sign an NDA that I couldn't share the information that was there until it went public. I don't know if they would have ever been able to prosecute otherwise, but are there things, I mean, what is your thought about an NDA in general?
Well, basically, there's three components that we see most of the time. One would be uh, confidentiality. That's fairly standard. There's nothing offensive about it unless they're asking you to keep confidential stuff that isn't confidential. So if there are industry practices and things that or that you learned before you even got there, they're not able to give you a hard time about that. It's really more things that you learned there that actually would be in the nature of trade secrets, or some other type of intellectual property. But kind of generalized information that should not be an issue taking to your next job, because otherwise, how would you be able to work? The second one would be a non-poaching clause. Don't steal our clients. Don't steal our members. Other employees. Don't urge them to go elsewhere, whether to your next place or someplace else. That's fairly standard, and there's going to be a time limit on that. And the time limit should be reasonable. We often see 6 months, a year, 18 months, rarely more than 2 years. And the third part is about you and whether you can compete with them based on a job that you take in the same industry with the same essential duties at the next position. Now, the question is, are there things that are in the non-compete or the non-disclosure that are so onerous that you see it up front and say to yourself, you know what? My career is going to be long, and I don't wish to lock myself into a place that's going to say, I have to sit out for a year or 2 years after I leave. That's a lot of money. Now, one employer that we've dealt with before, representing an executive, they had a very interesting provision that I actually heard that New Jersey was considering as a statute. I don't think it's gone anywhere to this point. And that provision said, we want you not to compete with us doing what you've been doing in another location, in another company. However, if we are serious about this and we tell you to sit down, we're going to pay you for the full extent of the time you're sitting out. You know what? I think that's fair. I mean, they're basically saying you're so valuable to us. We're so worried about you in the marketplace that we're prepared to pay you as if you were still here. Now, I'm going to say that's unusual. If New Jersey passes a law like that, that will be unusual. But I do get that what the public policy would say if that were to happen is, how important is this person anyway? My feeling is if that became a statute of New Jersey, most employers would not be enforcing these non-competes, because they would say, do we really want to pay this person for that period of time, plus whoever came after them, So it's just an interesting, as I say, a back and a forth. There's two sides to the policy.
I know what I've come up across when I was working as a developer is they want to see samples of my work, things I'd written, and I did it many years ago, and I regretted it. And what I started to say after that is, I'm bound by a clause that I cannot share specific information that I've done for other places. And I would say, how would you feel if I did the same thing for one of a client, another client. If I showed your work, I put it back to them. I said, I can show you an idea of what I've done. And I don't think employers realize that, because it's not a fair situation. I mean, what is that? And you don't know for sure what they're actually going to do with
Right.
whatever you share.
Right. Well, one thing that you bring up there that I think is extremely important is that you have to realize when you sign a a work agreement, like an offer letter, and say, yes, I'm agreeing to these terms and conditions, that's not a contract to keep the job, but it is a contract about what the provisions are, the bells and whistles. And there could well be non compete language in there. The reason to look at it carefully is that when you leave and go to the next place, unless those people are sleeping, they're going to ask you, or their recruiter is going to ask you, is there a non compete? What do you have that we have to know about? And why is that? Because at least in New Jersey, and I'm sure in plenty of other places, if you take the next job and the employer has no idea that there was a non compete that would have knocked them out, they can get sued also, which they do not want to do. And the reason is that essentially they are interfering with the first employer's rights in that contract, in those provisions. So I've seen this. An employer, a new prospective employer says to the candidate, we will be delighted to hire you, Ken, but we notice your non-compete agreement with the last employer says certain things. We need you to go back to them and get that stuff taken care of, get rid of it, do what you need to do. Otherwise, we cannot hire you. Now, that sounds like they put up a mountain. The truth is, the world is more complicated. So we did this with a gentleman who had worked for IBM and was about to get hired by another very big competitor of IBM's. And he came to me and I looked at the provisions and I said, do you have anybody back at the old company who was a champion for you? He said, yes, I have a high level exec who loved my work, was sad to see me go. And I said, can you ask that person to go to bat for you? Because it turned out that IBM and this company, they may have been competing on some projects, but they were cooperating on other projects. So this guy could be really a liaison between the two companies. And in fact, IBM crafted a 15-page exemption, which was probably longer than the contract to begin with, the severance agreement or whatever. And he was able to go to work. I thought that was great. And that's what people really need to do is be creative, go back, check, and see whether there's some way that you can then go forward and earn your living in the field that you have specialized in for a fair amount of time.
So Kelly asked, and this happens a lot of times with candidates, you get a letter and a better offer comes up maybe, or maybe something happens and you're not going to take the job. And legally, is there a repercussion if a candidate backs out of a signed offer letter? No, there's a difference between morally and legally. I'm just wondering from a legal perspective.
I would think the answer is no, because that offer letter is always going to say, unless you're in, the 0.5% of people who are in the level where they've actually got terms of, service, like a year, 2 years, 3 years. But for most other people, employers rush to say, I don't care what this says as far as vacation time and benefits and all the rest of it. You're at will, which means you can leave anytime without penalty and they can let you go at any time without penalty, as long as their reason was not discriminatory. That's the one difference between the employer side and the employee side. When you leave, you could leave because you don't like the makeup of the staff, or you don't want to hang around with people of a certain faith, gender, other. You can just leave, right? The employer cannot treat you that same way, right? But you can leave without penalty. The only thing I'm going to say is sometimes there are things that happen. So this may be like they pay for your MBA, or they give you a sign-on bonus or a moving bonus or whatever have you. Sometimes the offer letter will say, if you leave within X time from the time that you signed on and you got that money, you have to pay it back. That's totally reasonable.
Mhm.
You could negotiate, see if they'll let you go without it. But if they say no, we're sticking to it, you may well find yourself on the hook for that. But other than that, I don't see any penalty there. For example, if you have an offer letter and you haven't started, and there was a non-compete clause that was very onerous, you never came to work, right? So I don't think there'd be trouble there. I doubt that would be a problem.
One thing that I was a big proponent of early on is having companies develop a social media policy. Back in the day, it was a little different than now, but if you don't know what you can and can't do on social media, whether you're on LinkedIn or especially working from home, if I'm working from home and I'm taking a break and whether I'm going on Facebook or shopping or something else, and maybe my keystrokes are being monitored, whatever it is, if you don't know what you can and can't do, it's a very slippery slope. And I don't know if you have clients like that, or if that's something new you've been, having to deal with more than in the past.
Well, that's been around for, I'm going to say, at least 10 years, maybe more.
Okay.
There are lots of stories about that. There's an infamous matter of an employee in a private chat group with some other employees made an opinion about the boss, that the boss was a sphincter muscle. And that's all I'm going to say on that level. And boss found out about it and fired this person. That case went to Washington to the National Labor Relations Board that issued an opinion that said, in the context of employees talking with each other, even if they're using language that is obviously unflattering, you know what? You can't prevent employees from talking about terms and conditions of employment because, among other things, they might end up deciding to form a union, right? And so this inhibits their ability to correspond with each other. I had that issue in my office some years ago. I was sitting at an employee's desk and typing some things, and I saw, a message there, and it was on the work computer, and I clicked it open, and it was a correspondence between this employee of mine and her friend, and she wasn't very nice about me. So I did say something. I said, if you're going to have that conversation, best not to do it on a company computer, but I did not punish her at all. That just, I'm a liberal. So like, if that's the person's opinion, that's just how it was. But this comes up all the time.
Right, Lynn.
In every context you could believe, people who are in cases involving an accident or they're alleging some terrible thing happened to them and that therefore their physical abilities are limited, could be a disability claim from work, and they're posting the windsurfing competition they were in the Bahamas, and that has consequences. So we tell people from the day they come in, stay off social media when it comes to this incident, whatever it is that we're complaining about. Just don't get on there, even if it's complimentary. It doesn't matter. There are just certain topics that you got to stay away from.
So Lynn brought up the thing, and it was related to what you're talking about. Should an employee be asked to a meeting with HR just to go over should an employee being asked to a meeting with HR just go with their union representative, or should they have legal representation? Now, she's referring to teachers in school districts. I'm going to go in a different level. Let's say I'm having a performance review, or I'm possibly being fired or something, or maybe I'm being fired. What is my, at what point do I get a lawyer involved, or do I get them involved at the first time? I mean, it's a very, very slippery slope, because usually when you go to HR, it isn't necessarily anything good. They're normally going to question something. So from a legal standpoint, I mean, is there any general advice you can give?
These are excellent questions. I'm going to start with was it Lynn? Did you
Lynn,
say?
it was Lynn Williams. She's
Ah,
in Philadelphia. You're a great
I
career.
know Lynn.
Yeah.
Hi, Lynn.
Hi, Lynn.
So the first level would be this: the employer gets to pick the playing field. And if they want an employee in, if it's an issue of an investigation, a disciplinary matter, whatever, they're normally not going to open the door to have a lawyer present. There are exceptions. There are times if it's very troubling, if they're concerned that there might be a lawsuit or something, a lawyer could call up and they might say, yes, we're willing to have a meeting about that. Generally speaking, I wouldn't count on that. But what you can do is I can coach that person, which I do all the time. I have learned in part from the groups, the job seekers groups, PSG and the Greater Philadelphia group and others, that it never hurts to ask and you know in terms of what I consider my own work, is I say I'm a coach. I do coaching because I'm not being an advocate. I'm basically teaching somebody how to go in, take a particular position, back away, call me, and I say change it this amount. And it also depends on the employee's comfort level. Sometimes they have no interest in communicating, and at that point they say, look, you do it because I'm a nervous wreck, or I feel like I'm going to lose it or whatever. I'll call and I'll try maybe HR first, or I'll say put me on to the legal department. I almost never have a problem with that. Occasionally you'll get a difficult counterpart, whether it's HR or a lawyer, but most often they're fairly welcoming as long as we are being polite and respectful. They will reciprocate. And this happens where, for example, somebody says, I've been living with this and working in this environment for such a long time. I got to get out. They put me on a performance improvement plan, which in my lectures and workshops I call the kiss of death. Right? It's the avenging angel. You rarely get off that track well. Some people say they do, but it's rare. So once they do that, it's kind of a signal. We're watching you closely. You're meeting weekly, and at the end of the time period, I'm guessing nothing good is going to happen. So at that point, it helps sometimes to have counsel call and say, can we work this out in a cooperative way? You really don't want this person being here, I don't guess, and I'm pretty sure they're not so happy. Maybe we negotiate a severance agreement. Now, that doesn't mean we drop the issue of that there was discrimination or harassment or that you were a whistleblower. You can bring that up. I will say to them, if we have to do it, there's an uncooperative way that we would go. But part of the negotiation is to try to monetize your own upset as well as their desire to have this slate get cleaned. Also, the union piece, if there's a union, there's going to be a representative and they're required to be present with you. I guess you could waive that, but you shouldn't, because they're there to be the eyes and ears of the bigger group. So I do encourage that, but as far as the lawyering goes, I don't want to be in there too quickly. I don't want to get there too late. In law, we use the three bears rule, right? You want too hard, too soft, just right. So you want to get in there at the right time, say the right things, get to the right people, negotiate appropriately, and do the best we can. Some people will say to me, I don't want to sue these people. Mostly that's my advice anyway. If you're between 20 and 55, you probably shouldn't be suing unless your career is over at that point. If you're in your 60s, that may be your last act if you don't get a decent settlement, because it might have been your last job. So again, it's very fact specific and stage and age specific. I can't get further than that.
Right. So legally, is it okay for us as job seekers to actually record some of these conversations as long as we tell everyone, just so we have them, or not? I know now with that we all have phones and things, we could record stuff anywhere we go.
Right. So New Jersey's rule for a pretty long time, I want to say more than 20 years, is that either party to the conversation has the absolute right to record without asking or telling the other party. You actually do not need to ask permission. Interestingly, I had a case a few years ago where the employee, my client, confessed to some criminal conduct and said, I apologize and I'll work for free and this and that. The employer turned this tape over to the police and she ended up being charged criminally. There was just no way around that. So it's not exclusively an employee thing, but more often than not, it's the employees who take these tapes. There's nothing wrong with it. I can't say for a certainty because I've never been challenged on it, whether if the employer found out after you did this that they could fire you, and was that legal or illegal.
Well, I bring that up because what happened with Better.com when the manager had a Zoom call and he laid off 900 people on a Zoom call, and someone actually recorded the call and it went viral. And after that senior manager ended up taking a leave of absence. And had that not happened, maybe that whole behavior wouldn't have come out. And I think now, especially, we all have that ability. And I know we all have to think about what we say and do all the time anyway. But it definitely brought that to light.
As a matter of technology, it's pretty much akin to people filming traffic stops by police or some type of citizen police interaction. A simple phone call can actually, or a taped conversation in a conference room, can prove your point. So I will say we'll encourage it, but we just say be careful with it. And I'm not sure exactly what that means. I guess it means don't take it and put it on the table and say, okay, what do you want to talk about? I would say be subtle about that, but you can absolutely use that. Now, there was a time recently that New Jersey, I heard, was looking at some kind of a bill to change the one-party consent rule about these types of taped or videoed conversations, that it require actual consent. I checked fairly recently and I didn't see that having passed. But if that does, if the public policy of the state changes, then it would obviously not be permitted.
So this came up is, how about if the employer is out of New Jersey? Let's say I'm here in New Jersey and my boss is in Rhode Island and I'm recording a conversation. Is that kind of, I know you may not be able to speak specifically to every state, but would that be allowable, do you think?
Well, yes, because part of the conversation originated here, right? So at least half that conversation is a New Jersey conversation. So yes, and you bring up an important question, which comes up a lot, is what if you have out-of-state employers who you're working for, but you happen to be in New Jersey? What law applies? Does all the protection of the New Jersey law apply? And the answer is, it depends. There have been a few cases where the appellate division said, there are things called like choice of law. Where do we litigate and what law applies to it? But so I'm not going to say definitively. I can say this: if you're working in New Jersey for a New York company and the New York company lays you off, that's a New York unemployment claim. There's no question about that, and vice versa, right? You're in New York and you have a boss in New Jersey. The company's here. Your unemployment is going to be in New Jersey. But as far as what law specifically will apply, there's a number of factors that go into that. The other piece here, which I want to just throw out there, a lot of employers more and more are looking in their policy manuals, as well as sometimes a specific written contract, to say, if we have any dispute arising out of this employment relationship, and it could be 100 things. It could be salary. It could be discrimination. It could be whistleblowing. It could be breach of agreement of any kind. Those disputes are going to an arbitration panel or a single arbitrator for final decision, no right of appeal except as the statute might allow. Happens all the time. There's a new case that just came down in New Jersey. Um, what's the Raymore and Flanagan? They are notorious. They put things in this uh, employment agreement that say the statute of limitations on your claim is now going to be reduced, right? And they come up with all kinds of things like that. That's been disallowed. And they then gave the same unlawful contract to an employee after that. And the appellate division said the Supreme Court meant what it said when it did that. So you're going to have this type of thing where we have to look. I had one case where the arbitration agreement came out of California, but it was for a New Jersey job. New Jersey would never uphold this particular contract. There were problems inside with the language. How much did the employee understand about what was being done here? That we actually got the arbitration clause thrown out, which allowed us to go back to court. But I'm saying this is a big deal. It's everywhere, not just in employment, in consumer products. You know, you open a box of a new TV or computer, and there's going to be the bill of lading is going to say, you're going to arbitration and you can't have a class action. And the federal courts are going to look at that and decide whether or not to uphold that. And by and large, for the last 25 years, they have upheld that. So, you know, our rights as consumers, our rights as employees can be affected by things like that.
So this is a question that I get all the time, as you know, in my meetings. When a company doesn't provide feedback, is it because they're afraid of a legal concern or discrimination? They're afraid of what the repercussion would be, because we as coaches and recruit, and we all wonder about this when people ask us, why don't we ever get feedback from a company from a legal standpoint?
So you have to help me here. What kind of feedback are we talking for?
No, man, let's say I didn't get the job because you'd like to hear, I didn't get the job because A, B, C, and D. And as opposed to never hearing back, or you're missing skills A, B, C, and D, but actually I have these skills A, B, C, and D. So I mean, if the feedback isn't good, I mean, it opens up a different can of worms. That's, I think, the context there.
Right. I think that concerns about liability are oftentimes the best place to start.
Mm-hmm.
You know, it's a simple explanation and it's often accurate. I learned about Occam's razor, you know, the principle that oftentimes the simplest answer turns out to be the answer. Not always, but a lot. And I think that's a good basic understanding. You could look at it on the other side of the employment. When somebody leaves employment, the employers don't want to talk to future employers. So they'll say, oh, we're going to talk about, you worked here, these are the dates, and if you give us permission, we'll say how much you earned. Other than that, that's all they're getting out of us. You know, why would they do that? Because the ex-employee might fear that the reason they didn't get the job is they were blackballed. In fact, in the employment law community, believe it or not, you can hire a company to call the previous employer and say, I'm a prospective employer. Tell me all about Ken Lang. Can you go any deeper than that? And sometimes if it's an employer or a manager who's really kind of hostile, they'll say this and that reason. And now you know that it was really true. They were blackballing you. So, but mostly if they're doing what they say they do for the reason they say they do it, you're not going to get the full answer.
So this came up in one of our groups here. Is there any policy with people having the gaps in employment now due to COVID and all that? Again, are there things that can and can't be asked? I mean, I'm looking at a resume and I see there's a gap. Can I ask about the gap? Do I present the gap? I mean, again, this is let's talk about this from an employer perspective. What do you think they should, I mean, should they even be asking about it from the context of a job?
I have heard of nothing. I've seen nothing telling me that an employer is prohibited, or a recruiter, or an HR person from asking questions keenly, closely about that resume. What happened here and here and here? If it's out there as something they're not supposed to do, I've not heard that.
Okay.
Now, as far as turning it around, I think the wisest course would be if it doesn't come up, I would leave it alone. But if somebody asks a question about it, you have to be fully prepared to say, this is what that was about. This is why I did what I did. If it was a health reason or taking care of somebody else, or the employment coaches deal with these all the time, and if that applies to you, that's who you need to be talking about. I would say, not that I'd be hostile to hearing that question, but I don't have a great answer for how you should handle that.
Sure.
I think legally, I think that's an open area.
So Alex, who we know really, really well, asked about what COVID, how that impacted the legal relationship between an employer and employee. Like, for example, some places require the immunization and having proof of vaccination. Is that something you can ask on a job application? Is it something, if you want to, let's say I want to work from home because I don't have the vaccinations? I mean, basically, in a general way, I mean, this is a new territory for both sides, I would think.
It has been. That's been the biggest one. It's not the only one, but I'll start with the vaccine mandate. This was a massive fight between the right to self-determine and decide what you put in your body or somebody else does, versus everybody else's right to be protected reasonably on the job. And the employer is stuck in the middle. Why? Because the workplace is supposed to be safe from lots of different things, accidents, injuries, employment, like child labor issues. There's 1,000 things the employer already had on its collective plate, and then you put a pandemic on top of that. I would say most employers wanted to do the right thing by the employees, by which I mean take some reasonable steps to protect people. Some went to an extreme, but I would say the government, I was looking at the Equal Employment Opportunity Commission. They were issuing these sort of flyers, updates. You can go on today. You go on to eeoc.gov and look up COVID, and they've got their statements updated every couple of weeks. And there was a point where they flat out said it is not improper for an employer to mandate testing and say that a sick person had to leave, but they couldn't tell the rest of the people who it was, because that ran into HIPAA and privacy issues. So there was this sort of body of words and structures that led through to a position. But even in the last few months, the U.S. Supreme Court was asked, in the context of the federal mandate, could the federal government say, if you aren't vaccinated by X date, you're fired? And who was supposed to do that, I think, was OSHA or some group like that. And they said, no, that's not really your mandate. You don't have an enforcement role to play. So this has been very, very complicated. And but on the other side of it, there's a relationship of employees saying, I don't want to come to the office because I'm afraid, right? I had that myself. I've got a small office. I had an employee who said, I'm not comfortable coming back. And I said, all right, well, what if it's a big building, you stay on one side, other people are on the other. She said, no, what I'd rather have is that I'm the only one there. I'm like, I don't really think that's reasonable, but we ended up in doing what a lot of places did. People were working from home some days, and they were coming in other days. And over time, we have worked that out. So, but again, it's like, as an employer, I could have said, hey, you're at will, and if you don't show up, I'm letting you go. I had the right to do that, if an employee said, but I suffer from an immunodeficiency, okay, I have to reasonably accommodate, but my place is so small, I might not be able to do that. So there's a lot of this type of exchange that has happened. And of course, the job market tightened up so
Right.
that employers are more on the we need you side. So there's probably more accommodation now than maybe there would have been 2 years ago.
So I want to end with one question, I guess. Um, is there a best source? I mean, I know you've talked about employment coaching and the like, or that you coach. Are there some places that people can look to get information besides from yourself to talk with an attorney? Is there like a legal aid society or something that's out there, or do you not even recommend that?
Well, legal aid would only be helpful for people who are seriously in poverty. I mean,
Hmm.
we're talking for an individual who's making probably $18,000 a year and
Hmm.
doesn't own a car.
Right. Okay.
You know, they make many, many exceptions. What I would say is definitely worth looking at is look on the internet. You're going to see people like check out sites of people who do employment law. One thing I recommend is look for people who are involved with organizations like the National Employment Lawyers Association. There's a New Jersey chapter. There's like 150 lawyers listed there. You can find individual email addresses and just write and say, I have this problem. Would you answer it for free or for a reduced initial consult? That's what my office does. We say, we'll do, if you're vaccinated, we'll do it in person. Otherwise, it's going to be a phone call or a Zoom. And we do a lower rate for the initial consult than we ordinarily do for our hourly work. And I know other people do that as well. And some of them might even be free. They might do a free initial consult. So you should ask around, look around. One thing that's very interesting to me lately, I get calls from Cape May and High Point and all places in between, and nobody's worried about geography anymore, right? They don't say, are you next to the county courthouse? Because I'm not, if they're up there or down there. Because, for a year or two, the courts weren't even open. We do a lot of Zoom meetings with the court. So that's been a change, a big change.
So I want to thank you very much for being on the call. Now, would you be able to, after the call, go on to LinkedIn and maybe answer some of the questions we haven't gotten to just at some point? Because I want to make sure, if not, or just we'll talk later on so I can get the right answers, because I
No,
want to
I'm
make sure
happy to
that,
do that. I'm happy to
yes.
do that.
So
You just have to tell me where I got to go or
I
send it.
know. A little story about Hanan. Alex and I were working with him on his LinkedIn profile little by little by little, and he's gotten really good at it. And I think it's really helpful for you and for other attorneys to know not just how to use LinkedIn from a client standpoint, but from a networking standpoint too. And I'm so happy that you've embraced this as much as anything else.
Well, thank you, Ken. You've been a leader in that regard, and it's totally a pleasure to be here today and spend time with you.
Yes.
Look forward to
Thanks.
seeing you in person.
Yes, great. We'll see each other hopefully sooner rather than later in person.
All right.
Take care.
Take care.